Hello everyone, I am N.Kwashiwa, a third-year student at Herbert Chitepo Great Zimbabwe Law School, and my lecturer for this jurisprudence module is Mr. Nkosana. So today I will be presenting on the topic Ronald Dworkin. So the structure of my presentation will be as follows. Firstly, I'll provide an introduction which will answer the question, who is Ronald Dworkin? Secondly, I'll move on to present on Dworkin's assault on legal positivism. And this will include an overview of Hart's module of rules, Hart and Dworkin's debate, the distinction between rules and principles, the distinction between principles and policies, Hercules and Hart cases, the right answer thesis, the semantic sting, law as integrity, law as literature, and then a critique of Dworkin's work. And also lastly, I will look at the application of Dworkin's legal theory in the Zimbabwean context. So to answer the question, who is Ronald Dworkin? Ronald Miles Dworkin was an American legal philosopher, jurist, and scholar of the United States constitutional law. He was born in 1931, schooled at Harvard and Oxford University, and he subsequently died in 2013. So he has been labeled as a very influential philosopher of law. Why is this? His influence is based on the attractiveness of his legal theory. It is because his theory is placed in the middle of controversial theories, this being the natural law theory and the positivist theory. So you would see that with Ronald Dworkin, his theory has been labeled as the third theory, in a sense that it is neither naturalist nor positivist. Also, you would find out that his theory is largely relevant in the practice of judicial making. Why is this so? He introduces an artificial judge, Hercules, who is very fluent in addressing hard cases. So you would find out that in this regard, Dworkin provides a conception of how judges should adjudicate matters. So his theories are embodied in his books, which include Taking Rights Seriously, 1977, A Matter of Principles, 1985, Lost Empire, 1986, and Life's Dominion and Individual Freedom, 1993. So I'll then move on to look on the assault on legal positivism. So Dworkin's starting point might sensibly be regarded as his attack on Hart's model of rules in the concept of law. So the concept of law is a book by Hart. So his campaign against Hart's model of rules has been commended for providing the springboard for his denunciation of legal positivism. So before looking on the assault of positivism, I would first consider an overview of Hart's model of rules. So according to Hart, law is a system of social rules, and these social rules include primary duty-imposing rules, for example, criminal law, and secondary power-conferring rules, for example, private law. So according to him, he mentions three types of secondary rules, namely the rule of change, the rule of adjudication, and also the rule of recognition. So a scholar, Arawetz, refers to the rule of recognition as the most crucial part of Hart's model. So according to Hart, he argues that for every developed legal system, there is an ultimate rule of recognition. So what Hart is simply saying is that in every legal system, for a law to be valid, it has to be recognized. So we are seeing that Hart is actually advocating that as long as a law is not a source-based law, you cannot validate it as a law. So in this regard, Hart describes the rule of recognition in the United Kingdom as follows: what the Queen in Parliament enacts is law. So in his own words, Hart encompasses his model of rules by denoting that he denotes that the validity of these rules can actually be ranked. There is supremacy, there is one rule that overrides the other. So for example, in the Zimbabwean context, we can look at the constitution as a source of law being the supreme law of the land. So that is what Hart actually says. So according to Hart, he proposes that according to this rule of recognition, where a judge runs out of the law, we are saying where there is no applicable rule, the judge exercises strong discretion. He actually rules the matter according to his own conception. So the essence of Hart's work lies in his separation of law as it is and law as it ought to be. So having been given a comprehensive discussion of Hart's model of rules, I will then move on to look at the debate that Dworkin's 1967 paper, The Model of Rules, is that paper that offers this debate. So Dworkin finds that Hart's theory is under-inclusive. Under-inclusive in what sense? It is under-inclusive in a sense that he fails to appreciate that the law is comprised not merely of rules, but there are also non-rule standards that encompass the law. And he mentions, actually he labels these non-rule standards as principles. So according to Dworkin, the law is not only comprised of rules, but on top of those rules, underlying those rules, there are also what he calls principles. So Hart points out that rules are identified in all or nothing fashion. He says it's either a rule is valid or not. So that's the starting and the ending point. But Dworkin actually says underlying that rule, there are what we call principles. So Dworkin also rejects that the validity of law depends upon its sources only and not its merits. He argues that most law derive legal standards from the intrinsic merits. For example, no one may benefit from his wrong. In other words, Dworkin proposes that law must not be viewed merely as a system of rule, but as an enterprise with underlying values, and these values are principles. So in his debate, he gives a distinction between rules and principles. So according to him, the distinction is a logical one. While they both set out particular decision about legal obligation in particular circumstances, the difference lies in the direction they give. So according to him, a rule operates in an either or sequence. That is according to Hart. We're saying a rule is either valid, so if it is valid, it supplies the answer to the given case. If it is not valid, then it contributes nothing to the decision. So Dworkin refers to rules as something that, if valid, detect the result, come what may. So in this regard, Dworkin illustrates the nature of rules by comparing them to the rules of a baseball game. So he actually says it's either there is a rule that if the batter has 3 strikes, he's out. So if a batter actually wants an extra strike, that is an exception that has to be given to that rule. Also, he says, on the other hand, principles provide a reason for deciding in a particular way, but this reason is not conclusive. So principles have a weight and dimension which rules do not have. So he gives, in this regard, he gives the case of Riggs versus Palmer. So the grandson, being a beneficiary in terms of his will, he had murdered his grandfather. So the court has had to decide whether a murderer can actually inherit from his victim's inheritance. So according to Hart's theory of recognition, which says there has to be validity for a rule to be recognized, when we are applying this rule to the case, the will was validly executed and it was in the murderer's favor. You would see that in coming to the decision, the New York court considered Dworkin's principle, saying that there are principles that underlie a rule. So the court held that the rule was subject to the principle that no man can benefit from his own wrong. So there we are seeing the playing of principles underlying law. So as I mentioned before, that these principles, they are not conclusive. You would see that there are other cases where a man can actually benefit from his own wrong. I would like to bring your attention to the case of Cybron Corp versus Russian Limited. So in this case, you would find out that it was held that there are other circumstances wherein a man can actually profit from his own wrong. So unlike rules that conflict, competing principles can actually coexist in law. Rather, they have to be balanced and weighed, and the best in a given context is applied. So an illustration in this regard will be the case of vicarious liability. You'll find out in the case of vicarious liability, there are two competing principles. That is the principle of individual autonomy, USA electoral law, and those principles have been weighed and balanced, each case upon its merits. Hence, it is proof that two competing principles can actually coexist. However, these principles have been criticized for making law indeterminate, where these conflict. So in line with this criticism, Hart points out that these principles, unless they've been endorsed as legal principles through a rule of recognition, they are not legal principles, but external moral principles, which is actually separate from the law. So here we see hard separation of law and moral principles. So in response to this, Dworkin stipulates that there is no rule of recognition that enables a comprehensive distinction between legal principles and moral principles. Dworkin also moves on to differentiate between principles and policies. So according to his differentiation, while his principles describe rights, policies describe goals. So Dworkin's argument is vested in his work taking rights seriously. So according to him, the rights of individual triumph over those of the community. So he poses the central question that in any litigation, the central question is whether the plaintiff has a right to win, not whether the community's interest should be taken into consideration. So for Dworkin, the realm of a policy does not give rise to the rights of an individual. So we are seeing that he's saying the rights of an individual must triumph over those of a community. I'll then move on to look on the case of Hercules and Hart cases. So in his formulation of how judges should adjudicate over cases, he rejects the formulation by Hart that when a case arises within the open texture of a legal rule, that is to say, where there is no certain applicable rule, a judge has a discretion to where there is no applicable rule. But Dworkin is not in line with this, because he says this invests judges with strong discretion, and this discretions can be subjected to abuse, as a judge is not bound by any standards in the law. So he says this is likened to giving a judge the power to manufacture a fresh legal rule, and this is against the principle of the separation of powers. So according to Dworkin, in the case of hard cases are those cases in which a fundamental proposition of law is disagreed upon by lawyers. So according to Dworkin, he advocates that in such a case, the judge must give effect to what is implicit in the society's moral fabric. So we are seeing that Dworkin is advocating for the taking into consideration of moral principles. So in this regard, he creates Hercules, a judge of superhuman skill, learning, patience, and acumen. So Dworkin's Hercules owes its existence to the to the portrayal of law as a gapless system. In other words, there is no way that a judge can run out of law. So the judge Hercules stands for the model of a perfect judge who, in deciding hard cases, begins by constructing a theory of law applicable in the best light. I will then move on and look at Dworkin's one right answer thesis. So according to Dworkin, he proposes that to every legal problem, there is only one right answer. So he rejects the strong discretion of judges. He's saying there is only one answer. So in Hercules, according to Dworkin's Hercules, he will find the best answer to the legal case before him that comfortable fits the case. So in illustrating the duties judge in hard cases on the basis of a one right answer thesis, Dworkin uses an analogy of this persona Tao in a chess game. So Tao smiles to his opponent. His opponent actually unsmilingly objects. So in this case, he presents this as a hard case in which there is no rule according to the chess game, in which we are saying the smile maybe is it is not according to the chess game. So in this manner, the referee, according to the one right answer thesis, has to determine whether this smile is according to the intellectual nature of the game. I'll then move on and look at what Dworkin refers to as the semantic sting. Ronald Dworkin in Law's Empire utilizes what he describes as the semantic sting to explain why the concept of law is a contestable one and why it is essentially interpretative. He asserts that in several occasions, lawyers frequently agree about the facts surrounding the creation of a particular rule, but they disagree whether those facts are sufficient to be vested with legal authority. So this disagreement relates to the criteria of legal validity, which according to Hart is exhausted by the rule of recognition. So the essence of his argument is based on the criticism of positivists that claim that value-free theories of law exist. In other words, he rejects the existence of such theories in the sense that by denying the legal positivists are denying the need for the interpretative attitude, because they are saying we know what law is simply by attending to the way people describe law. So Dworkin calls this the semantic sting. This is what Dworkin calls his semantic sting. So simply put, the basis of legal validity cannot be exhausted by a shared criteria contained in the rule of recognition in a case where two lawyers are actually in dispute. I will then move on to what Dworkin refers to law as integrity. So at the core of this theory, which is key to Dworkin's constructive interpretation, there is the need for a judge to ask whether his interpretation of law could form part of coherent theory justifying the whole legal system. So he does not define the concept of integrity, but rather he provides a portrayal of its significant features. So the essence of law as integrity lies in the relationship between law and force. So he argues that law is a tool that is used to justify coercive force. So he bases this on the grounds that a society that accepts integrity as political does so in order to justify its use of coercive force. Also, in terms of his law as integrity, he actually says in interpreting law, we have to include things like equality, integrity, and the likes. He also refers to law as literature. So he compares theories of legal interpretation with literary theory. For Dworkin, law is an interpretative concept, and legal interpretation is creative, not reproductive. So this is similar to the work of art. That is why he refers to law as literature. Having provided a theoretical approach to Dworkin's work, I will then move on to look at the critics that have been leveled against this philosopher Dawkins. So these are numerous. So it has been argued that Dawkins' assault against positivism is actually baseless. Hart acknowledges that he said very little about principles, but then he says there is no way that these principles fail to enter inside his realm of the rule of recognition. So he's saying the principles can actually be incorporated into the rule of recognition, meaning that at the end of the day, according to Hart, Dawkins' argument holds no water. So there is no such thing as his assault of legal positivism having value. Also, scholars like Kress criticize Dawkins for introducing a more complicated third theory. We are saying already there is a dispute, a controversy between the naturalist and the positivist theory. So he goes in between and actually creates a more complicated theory, which is in the middle of these. Thus, we are saying that Dawkins does not provide any solution to the controversy that is at hand. It has also been argued that the introduction of principles creates more hard cases as it shifts the boundary of what is settled as law. This is the issue with easy cases. It has been argued that there is no such thing as a single right answer to hard cases. So proponents for this include Mackey and Husler, who point out that there are cases where there is no right answer at all. An illustration in this regard is a situation of two opposing propositions that a contact is valid and that a contact is invalid. So in this case, Dawkins ignores the fact that both answers can actually be wrong. Also, an argument to the effect that judges regularly decide cases with reference to policy consideration has been made. We're saying that Dawkins says you cannot refer to a policy when you are adjudicating a case, but then there are cases where policies are taken into consideration. For example, when looking to third-party beneficiaries in the law of delict. Dawkins has also been criticized for his failure to adequately define a hard case. So according to him, all cases are hard cases. Also, the imaginary judge, Hercules, is objectionable. The objections leveled against him are that he's a politician, a tyranny, and also a judge who behaves in an utopian style. So in this case, proponents for this are saying that this Hercules is nothing compared to a real judge. Also, a number of commentators have said that Dawkins' model of law travels badly, in the sense that it is centered in a liberal, democratic American view. So we cannot apply this to unjust societies, for example, corrupt societies. So nevertheless, Dawkins is prepared to doubtlessly defend his theory against such criticisms. Some of his responses are contained in the following works: Reply to Criticisms in Taking Rights Seriously, a reply by Ronald Dworkin in Marshall Cohen, and also Ronald Dworkin and Contemporary Jurisprudence. I will lastly look at the application of Dawkins' theory in the Zimbabwean context. So yes, we are seeing that in Zimbabwe, the new constitution, the current 2013 constitution, is based on the founding values being dignity, equality, and freedom of an individual. That requires the law to be interpreted and developed in line with these rules. So we are seeing that this is in line with Dawkins' law as integrity, Dawkins' proposition that in interpreting the law, you must take into consideration principles, moral principles, and the likes. So I would like to bring your attention to the South African case of S versus Makwanyane having persuasive value in Zimbabwe. So this is an example of a hard case. A hard case defined as a case in which the fundamental proposition of law is in disagreement. So in this case, the disagreement was on the constitutionality of death sentence. So you found out that the judgment was based on the facts that the rights to life and dignity were the most important of all human rights and the source of all other personal rights. So you see that here the theory of Dworkin that the rights of an individual must triumph was taken into consideration. So you would see that Zimbabwe is actually endorsing Dworkin's theory, but then you would discover that with our Zimbabwe we have high issues of corruption. So how then can we incorporate such a theory that is based on a liberal democratic society? Point to ponder. So to sum up, it is clear that although the criticisms leveled against Dworkin cannot be overlooked, Dworkin's theory has developed an originally and highly influential legal theory grounding law in morality, characterized by unique ability to tie together philosophical ideas and arguments with concrete everyday concerns in law. So it also provides a balanced solution between the controversies between legal positivism and natural law, although this is debatable. Therefore, it is safe to conclude that Dworkin has played a very pivotal role in jurisprudential development. Thank you.